So when we look at information generally, we need to distinguish information from trade secrets. Information like general skill and knowledge, how an organisation runs, just your general know-how is not protectable. You cannot protect that kind of information. We're looking at something more, something higher. We're looking at the information which, if your competitor knows about it, it will damage your business. So when we're looking at what you can protect, that's the realm we're moving in. So step one is thinking, do you have anything that is legally protectable? And you may not. So your first analysis needs to be that. And the other thing is, you may have information which, for example, your customer base, those people's names and that kind of information. You don't want a competitor necessarily to know your suppliers and your main customer base. You need to move that into the realm of confidential information. I want to talk about a case called Cummins Chicken. I love the name of that case. It's a very old case. Well, 1986 it went to the Court of Appeal, and it's a very famous case. And it's the leading case in the area of information and how we define information. What it's about is the plaintiff, so the business owner, had a sales manager, called him Mr. A, and while he was working for Tashanti Chicken, he devised a system where you would sell fresh chicken from the back of a refrigerated van. So he devised a system, and then all the staff went out, so all the van drivers, and they went out. So within a couple of weeks, they knew the special routes that they needed to get to particular customers, all those customers, the different prices those customers wanted, all their individual needs. They had all this very special knowledge for this way that they were working. Anyway, Mr. A resigned. He resigned and he started up his own business, doing exactly the same thing in the same area.
Can you show this date?
The plaintiff sued, and what he said was that the individuals, so Mr. A resigned and he took staff with him. He took about 8 members of staff, including the van's salespeople. So they all went off to join Mr. A and started off this competition against the plaintiff. The case wasn't about not setting up a competition. The case was about what information could be shared and what couldn't be shared. So it's very technical. And what the plaintiff was saying was that these van salesmen had gone and given this information about who the customers were, the special routes, the delivery prices, which was enabling Mr. A to have a competitive practice. So what this case did was it defined 3 categories of information. The first category is easily accessible information to the public. So that is information that you can use during your employment and after. And it's probably lost its confidentiality because it's already in the public domain. So that's the first category. It's easily accessible to the public. The second category is confidential information. So you're not allowed to use that during your employment, but you can use it after, unless you have a restrictive covenant that restrains the use of it. So when you're during employment, you can use it for specific purposes to do your work, but you're not allowed to share it outside. And there's a fidelity obligation of an employee that needs to keep that information confidential. But the minute they leave that employment, unless you have a restraint, they can use that information. And the third category is trade secrets, which we've discussed. When it comes to trade secrets, they have a very special protection, which doesn't need you to have any clause or anything. It's protected by something called the common law, which means that you don't have to, it's automatically protected. You don't have to have a clause in an agreement. It's the Coca-Cola situation. So anyway, in this case, the information fell within clause 2. It was confidential information, but without a restraint clause, they could use it. So the plaintiff lost, and this Mr. A was allowed to set up in competition and use all this information and gain a competitive edge. When we come to employees, there are things called implied terms. So the very status of an employee gives a certain obligation which you don't have to write down. You have to be able to have mutual trust and confidence, and have fiduciary confidentiality duties. Non-employees, apprentices as well, contractors, they don't have this. So if you want to put an extra duty or have certain promises from them, you need to be putting that in a contract. Fiduciary duties, these apply to directors or partners in your business. Because of the special status of that relationship, again, there's certain implied trust and confidence and responsibility simply by the status of their title in your organisation. So when we're coming to practical steps, I've listed a few examples start moving things out of that grey area of general skill and knowledge and organisation of documents and make them more in that highly confidential realm. Okay, the outside world then. We've already spoken about intellectual property rights. That's how we begin to build our ground. The next thing I really wanted us to make sure we're thinking about is social media. As we were talking earlier, Sadeep, it takes 20 years to build a reputation and 5 minutes to ruin it. So again, when we're talking about do's and don'ts from the outset, you want to be having it very clear how people are using it. If they're on Twitter or they're putting the name of the company, have it made clear all thoughts and all expressions are nothing to do with, whatever, John Lewis, whatever, make it very clear, because this impression is massive. Our Google pages, they're like the front of a book, the front cover of our book. You need to have those protections in place. When it comes to monitoring and guiding people, you do need to have a policy in place, because otherwise you're risking infringing people's privacy and their human right, obviously, to express themselves and all that sort of thing. So you do need to have put in writing that you're going to do it, so that they're on notice and they can modify their behaviour accordingly to fit with what you're doing. Obviously the best thing ever is to be able to have working relationships that are healthy, to be able to have reliable people. That goes back a lot to the recruitment stage, the people you're getting in the first place, the vetting stage. Know what your expectations are. Don't make rash, quick decisions when you're hiring people, because people retention and building those relationships, that is actually the best way to protect your business. Have owed loyalty from people, give them prospects of progression so that they feel that their life is part of the organisation and where your vision is. The length of the notice period is important because it's relevant to your business and the kind of business that you have. You want to give yourself a notice period so that you've got time to find a replacement, that the business isn't going to fall down within it, but the length will be different. If you've got someone who's maybe doing a very client-facing role, 3 months would be sensible, because then you've got time to do a handover, to wean the client away and reallocate business. But if it's not so client-facing, a month, 2 weeks will probably be enough. The law does give you some minimums that you can't go beyond, which is probably too technical for here, but it's kind of like a week, a month, and depending on how many years they've been in service, that length will extend and you can't go below that. But so therefore, next, very importantly, pay in lieu of notice clauses. Sometimes you do want to get that person out immediately, you need to get them out immediately. If you do that without a pay in lieu of notice clause, it's an unfair dismissal. You must give the minimum notice in law is a week, and that normally after the end of a year, that's gone up for staff. So your restrictive covenants, the way to make them legally enforceable is first of all have a legitimate business interest to protect. So that goes to what we were talking about at the very beginning. Is the information you've got in that realm of highly confidential? The business contacts you've got, can you start to protect them and can you prove that, well, look, I've told them this is in the realm of confidentiality? Step number one. Step number two is it reasonable? And reasonableness is covered under these three headings: market, area and time. There was a famous restrictive covenant for a milkman that said he's not to sell milk anywhere whatsoever. Unfair, he's a milkman, that's his trade. Area. Employee must not be required to move to another locality to carry out their business. This is quite interesting because for things online, that's a different headspace. None of these things, there's no one size fits all. What is the relevant or reasonable market and area and time length will be different for every kind of business. For an online business, it's really shorter, but we can be looking at maybe who the market space might be different. So your specific competitors are the people you say you can't work for that particular person and that particular person for 12 months. That would be reasonable, but you couldn't say, worldwide, but then for a hairdresser, that's a very personal contact. So you could say you can't work in hairdressing in Brixton and a 5-mile radius. That would be reasonable because of the personal contact. But the most important thing always is to have the moral high ground, and it's genuine to yourself and your business and how you function, because that's what the law is trying to protect. Have a legitimate business interest, because that kind of competition is interesting. It's not unique enough.
No.
It probably wouldn't have many things. I mean, Pretender Chicken is interesting because that was just a guy selling chicken. But the point was the customers that he was going to. So if you are a local business salesperson, but you've maybe got a specific customer base, maybe your suppliers, and the rates that you're dealing with your suppliers, that sort of thing. That I guess the best way to always think of it is, if a competitor knew this, could this give them a competitive advantage over me? With a market salesman, there's not many things that would give them a competitive advantage as such, because you're just neutral in a way. So he'd set up a special thing of selling them from the refrigerated van. So he then upped it to the next level, something different to what all the other chicken sellers were doing. But he took that idea and he set it up again. And that was putting him in a unique thing. The general skill of the trade and the know-how. So yeah, for the market salesman, I mean, for Anita, you will have quite a lot of legitimate business interests to protect because of your uniqueness in the area. So yeah, that's right. I think people can get excited thinking, oh, you've set up in business, but you have to get over it. The courts will encourage that, if anything. They want people to be competitive because that's better for the public and it's better for prices and industry.
So the court just wouldn't listen to that?
No, you would have nothing. You would have nothing. Outcomes you can get. So if you did go to the court, what could they do if you were to win? You can get an injunction, so that basically stops them immediately. So if Pretender Chicken had won, they would have stopped that business. He couldn't sell the chicken anymore. They could have got damages for financial losses. So if you could prove what I've lost as a consequence, he's stolen all my customers, she's stolen all my this, then the money they've earned, they'd have to pay you back. The same for account of profits. They'd have to prove the profits that they've made and pay that over to you. So it is very powerful. And the idea is to put you in the place you would have been had the breach not occurred. Powerful results. I'm going to tell you about a case that happened this year that involved Craig Harrison. Craig Harrison is a Michael Jackson impersonator. He was employed by a company called Trevor Chance's Legends, which is a place in Blackpool, and he was part of lots of other performance sets, and they're doing all this impersonation thing. He quit at the end of the summer season, last summer, 2015. But then he went and took up another job with this Kings and Queen of Rock, Pop and Roll. I don't know where the other queens are, but it's Kings and Queen of Rock, Pop and Roll at the Central Hill Show Bar, which was a direct competitor of the Trevor Chance's Legends. Now, they had put a covenant in Craig Harrison's contract, and it said for 12 months from the end of his contract, and his contract ended in December 2015. It said for the next 12 months, you're not allowed to go and work for a competitor. So obviously, Trevor Chance's, the old employer, was like, right, boom, that's it. You've just blatantly breached the covenant. And they took it to court. Now, Craig Harrison won his case. And he won not because there was no breach. The court said there was a breach, but the old employer, Trevor Chance's, had delayed in bringing their case to court. So Craig Harrison had begun working at the Kings and Queen of Rock, Pop and Roll in January. Trevor Chance's, the old employer, wrote to him in March threatening him to stop. You're in breach, you should stop. But they didn't take it to court until May. Now the court said, if you'd come in March, we would have granted you this, and we would have given you an injunction, and he would have had to stop working. You've waited till May, and you can't explain why. And the result of this is that you have left it to the beginning of the very lucrative summer season. They're not going to be able to find a replacement. Him leaving now is actually going to affect the staff there. They lost the moral high ground. So it's very interesting, and the point of that is to remember they always want to encourage trade. They're not going to be stopping it for any old reason. It's very, very difficult. You must always keep the moral higher ground. You must always be genuine and honest and act fast, because they're basically saying you're being manipulative. If this was actually real, you would have begun it. You waited, and you can't tell me why. So deal with it. The lesson, I think, is integrity, to be honest. In all honesty, I think the lesson is integrity, because it does come back on you. If you have a genuine issue and your business is being threatened, you act on it. you have done the foresight, which I've now blessed you with this morning, to have put things in place, to have analysed your information and put your situations in place, so you've anticipated the risk, and then when it happens, your eyes are open and you act, and you let the law help you protect your business. But it is your business, and it is law, and it's not for me to tell people you must or mustn't, but I do hope to help get people's minds in a place that can protect their business, because it is that, and it's separate from family and all those other things, and you want to get that right, and all the love and care and creativity you put into it, it's worth it. Like, why is it not worth it? Yeah, and it's risk. I'm dealing with a case right now on restrictive covenants, and it's messy and it's ugly, and a lot of it is bad feeling, because when relationships end, you've worked with someone maybe 20, 30 years, then these relationships end, it goes down fast. If you just have these little things in place, it's amazing how much it can make it less painless than it needs to be, which is what this is all about. The law is there, you might as well use it. It's not just about it restricting you, it's about understanding it and manipulating it and letting it work for you too.
You know, one pager is all you need.
Yes.
You know, just a one pager and a quick signature and you're good.
That's it.
Put that in your folder.
That's it.
And that's you've focused me, because it's something I've been avoiding.
Okay.
So
Yeah, just
We do have, you know, charities poaching staff, especially fundraising people. So yeah, I think definitely there has to be some sort of clause in place in our contracts, restrictive clause saying that we cannot share this information.
good idea. Good idea. Yeah. If anything, so you can bring people up on it as well.